Welcome to the NALSAR Public Policy Podcast. I'm Gour, and I'm a fourth year student at NALSAR University of Law and columnist for the Law in Tech column at The Leaflet. Ladies and gentlemen, it is both overwhelming and rare to live in a time when artificial intelligence is impacting society horizontally with the promise of unprecedented efficiency and transformation. At the same time, we are witnessing a world where even sustained diplomacy is struggling to respond to complex and evolving geopolitical realities. Against this backdrop, I welcome you all and I'm delighted to host today's podcast on Indian Digital Personal Data Protection Act. This is India's first comprehensive data protection legislation and a landmark in the country's digital regulatory history. The Act gives statutory shape to the right to privacy, which has been recognized as a fundamental right under the Constitution of India. Our guest today is Mr. Nikhil Narendran. He is a partner and head of Digital Innovation Group at Trilegal and president of the International Technology Law Association. He works at the intersection of technology, law, and society, advising leading telecom, e-commerce, media, and technology companies on regulation, disputes, and complex transactions. His areas of expertise include artificial intelligence, cybersecurity, data protection, content liability, satellite communications, and cross-border technology deals. Recently, he was appreciated by the Editors Guild of India for his commitment to upholding the voice of free journalism. He is a prolific writer and speaker on technology policy and governance. He is a filmmaker and he's someone who deeply cares about human rights, values, speech, culture, and history. Ladies and gentlemen, he has been closely engaged with the evolution of India's data protection framework for as long as the law has been in the making. Welcome, sir, and thank you very much for joining us today.
Thank you, Harsh. Thank you for having me here.
So to begin with, I would directly like to step into the regulatory design of the Digital Personal Data Protection Act. So how do you assess its architecture in terms of protection of data principles, in terms of regulation of data fiduciaries, and in terms of the position it assigns to the central government in terms of rule making, control, and oversight within the Act?
So, interesting question, Harsh. So, to talk about the regulatory design of the Act per se, look, the design has been in the making for several years, starting from the time we first looked at whether we need to have a right to privacy law or whether we need a data protection law, because informational privacy is just one aspect of the various facets of privacy itself. And what the Digital Data Protection Act does is, it largely deals with informational privacy aspects of data which is in the digital form, but excludes all other aspects of privacy from its ambits. And it deals with the digital form of how to protect someone's informational privacy, which may have inclusions relating to mental privacy, other aspects of privacy, right to be let alone, communicational privacy, etc. in the digital form. And while doing so, what the government has done is that it has ensured that it is not a very compliance heavy framework. It is in fact a light framework compared to some of the examples that we have in the world, for instance, the GDPR.
Right.
It is not necessarily focusing so much on creating a litigious society around the right to informational privacy, but focus on some sort of an accountability framework which can then be implemented by the companies. But in the process, there are some few aspects relating to the regulations which are clearly emerging. One is the fact that the data principle, or the so-called digital nagrik, the main purpose for the Act, while maybe to empower the digital nagrik, the data principle has probably the least amount of power in the frame of things.
Right.
Large amounts of power and responsibility is given to data fiduciaries, especially those data fiduciaries who are in the private sector. Government is also a data fiduciary, but they have been given probably a sort of a leeway or an exception when it comes to dealing with aspects relating to digital privacy governance. They get away with a lot of exceptions, a lot of exceptions from consent, a lot of exclusions from the Act itself. Then there is a data protection board, which is a sort of a semi-autonomous body which derives its powers from the Act, but is appointed and to some extent is under the supervision of the government, and they act as some sort of a body which collects all the complaints from the data principals and decides whether to proceed an action against the data fiduciaries per se. So it acts as some sort of a collection point for these compliances and grievances. And then there are aspects such as voluntary undertaking, whether the companies could come and submit saying that, look, I made a mistake, I'm sorry for what I've done, and can go forward. There is a provision for mediation, and the government is probably the all-powerful entity in the law. So if you just look at the sort of power equation or the power dynamic of this design, the data principles have the least amount of power. The government has the largest amount of power, and this is a very interesting framework which has been put in place, like I mentioned, to avoid a litigious society in terms of while exercising a right to privacy jurisprudence. But at the same time, the question is, a data principle is not entitled to a compensation for a harm done to it. Then is it achieving the full constitutional, is it granting the full constitutional protection as it should, is a question that is now relevant, and these are some of the features of the regulatory design of the Act itself.
Right. So I see that the Act introduces new terminology like data principal and data fiduciary instead of GDPR style data subject and data controller. So what do you think? Why that choice, and does it change the legal framing of it?
So I think the credit should goes to Justice Sri Krishna, the prolific author behind one of the first versions of data privacy law and the detailed committee reports that we have seen. I think the credit really goes to him to come out with these terms. And I would say, look, in terms of definition, these definitions are very similar to the definitions that you see in GDPR or similar sort of a statute when it comes to data fiduciary and data principle. Having said that, look, to frame it as a principal and a fiduciary as opposed to a controller and a subject, one grants it a personality. It sort of assumes or presupposes a situation where a principal has control over the data, and a fiduciary is basically keeping the data in its fiduciary capacity. Now, nothing is mentioned in the Act in terms of whether it actually treats or creates a fiduciary responsibility between a so-called data controller and a data subject. It doesn't say anything to that extent, but it's open for the court to interpret, and I'm assuming the terminology itself will actually create some sort of a relationship between the two parties where there is a presupposition that a data fiduciary should not do anything which is not in the interest of a principal. That framing and those sort of concepts were the feature of the previous versions of the law, which Justice Sri Krishna had put out, which now is absent. Some of those frameworks relate to the fact that, look, a fiduciary should not do anything to the detriment of the principal is absent. Specific statute to that extent is, specific wording to that extent is absent in the statute at this point of time. But having said that, it will be interesting to see how the courts will take this, how the courts will take this framing, and how the courts will, given also the power equation that I mentioned in the regulatory design part of it, will use to interpret, will it cast additional obligations on fiduciary on account of this? Will it cast additional obligations or duties on the principals on account of it? That is something that we need to watch out for.
Right. So to moving on, I see that Section 9, it clearly restricts the processing of children's data, and it bans the behavioral tracking of the children. Then how should we really interpret phrases like, quote, likely to cause any detrimental effect on the well-being of a child, unquote, and what will be its evidentiary standard?
So it's a difficult question. So I think if you ask any parent what is to detriment to the well-being of a child, I'm sure every parent will have an answer to that question. Right. So probably you will interpret this better when you are also put in a similar sort of a situation, if you are ever put in that similar sort of a situation. So the way that I would imagine detriment to the well-being of a child, simply means that, look, the data which is processed by a data fiduciary, if it's children's data, it should not in any way be against, in any manner, against the interest of a child, whether it's a mental well-being, whether it's a physical well-being, whether if there is a whether there is a reasonable duty to protect the child itself. That is sort of imbibed into the act when they say that it should not be detrimental to the interest of a child. A very classic example for that being, for that matter, is the fact that directly targeting advertisements at children, which, let's say, promotes unhealthy eating habits,
Right.
or for that matter, which promotes binge watching of certain form of content.
Right.
These all could fall within the bracket of something which is detrimental to the well-being of a child. So the overall well-being of a child, both mental, physical, safety-wise, should be looked into while interpreting this particular clause.
Right. So the Act, it allows processing for certain state schemes, particularly under Section 7, in order to determine eligibility for other benefits. But interestingly, who ensures the transparency and accountability in such state processing? And how do we hold the state to standards required of data fiduciaries?
So it's a debate which has been going on since the time we started talking about the Personal Data Protection Act somewhere in 2016, 2017, because we all know that if the government were to truly classify the state or the government as a category of enterprise, then it should call themselves a significant data fiduciary, because government is
Right.
arguably one of the largest
Right.
significant data fiduciaries in India, and ideally the government should notify itself as a significant
Yes.
data fiduciary,
Yes.
and it should conduct a data protection impact assessment on itself.
Right.
It should appoint third-party auditors to do that, come out with periodic reports. It should have a DPO, etc. That should be the best way. That should be the most transparent and non-arbitrary way of enforcing the data protection regulations. But having said that, what we have seen is that the government has given itself a lot of exceptions. Those exceptions are not necessarily from Section 7. Some are very needed, right? Some are, one could argue whether it's needed or not. But in any event, one should assume the fact that, look, when the state is trying to do its function, often taking a consent is very difficult, and that's why some of the exceptions are given. So that's a fair call by the state not to overtly rely on consent as a basis of processing. But having said that, the state is still supposed to come up with governance mechanisms in the
Right.
way in which it had handles data. There are some aspects relating to the governance, including unless certain items are required to be kept for the purpose of law, there are governance rights and entity that a data principal can utilize. They can also have grievance against the state. They should also now have internal governance mechanisms, including DPOs, to ensure that the data processing by the state is carried out in a mature and a responsible manner as required by the Act. So these are all some of the obligations that the Act is imposing on the state in any event. Now, like I said, dealing with state is extremely difficult because of the fact that will the Data Protection Board ever find the state? Right? It's a question that we need to watch out for.
Yes.
And if the state is being fined, right, does it really make a difference? Because it goes from the consolidated funds of India,
Yes.
and it goes from our money.
Yes.
So even let's assume that there is a section in the state which is misusing the data. Unfortunately, the pinch is not on them; it's on us. So the way to really hold the state responsible, we will have to go and rely on some of the other tried and tested ways in which privacy rights can be exercised. One is definitely by way of jurisdiction.
Yes.
That remains as one of the means to ensure that the state is accountable for the data processing it does. Secondly, the other way to do this is, of course, by your voting. Right?
Yes.
I mean, democracy is still will remain as one of the ways in which you can exercise and hold the state accountable for the data processing that it does. And hopefully, what we have seen is that we've seen a lot of steps by the government in terms of furthering the objectives of responsible data processing. Several governments are coming out with schemes around how to process personal data. They're coming out with non-personal data processing schemes and open data schemes, etc. So hopefully in some time the government will also start building better measures within which they manage our personal data.
So it's about waiting for some time.
I hope so, because this act is a new act and it's just taking shape, and we'll have to give everyone some time.
Right. Right. So Section 17 and related exemptions appear wide, and I've read the section 17 as potentially problematic. If I remember correctly, your team at Trilegal is analyzing constitutional issues here.
So, I mean, look, 17, I would not call out on a limb and say that section 17 itself is problematic.
Right.
There are some sections within 17, it's not very entirely clear whether those functions need to be done by the state, or is that something that's available to the private party itself. So there are some confusions and doubts about some of the aspects of section 17. There are sections which deals with the government declaring the act to be not applicable to certain segments or sections, at least for some period of time or for a longer period of time. If the government is exercising its rights within these sections in a non-arbitrary manner, then that need not be taken up before a court as a challenge. But at the same time, there are some other provisions which grant large exceptions or exclusions from the act itself. These also would have to be tested on a case-by-case basis. So I wouldn't necessarily say that Section 17 is per se unconstitutional, or there are some deep problems with Section 17 itself. I would say that how those powers will be exercised, how the powers will be exercised by the government, and how these exemptions are handled by the government is something that we need to watch out for, and need to look at it on a case basis. And honestly, look, we've probably passed an era of the judiciary where mere existence of a section is often declared as unconstitutional. It's just the way in which the power is exercised pursuant to those sections are usually called upon in question before a court, and that's why the courts really step in. They also need to see not just the probability of a harm, but actually a harm that's happening from a constitutional perspective. So it'll again, I would say, it'll have to stand the test of time. Yeah. We will see instances where at least some of these exercises may go to court, and we will see it at that point of time.
Right. So on the similar points relatedly, Section 36 and 37, it gives the central government wide powers to call for information and direct blocking of public access in the interest of general public. So how do you see, how real is the risk that these powers could be abused, and what sort of safeguards should exist?
So look, I think Section 37 is, for that matter, a fairly detailed section which talks about, I believe, multiple non-compliances. If those multiple non-compliances are not done, then upon the recommendation of the board, then the government can issue the power to block an app. I mean, for instance, let's assume a situation where there is a very egregious video of someone's now non-consensual imagery, or a CSAM content is being percolated, and despite several warnings by the government, the particular platform or entity is still not doing the adequate step to curb that particular personal information being disseminated. It's only those instances that 37 should be used, and one can only hope that the government will use it sparingly in a responsible manner, so that it never goes before the court as an unconstitutional use of the powers granted to the executive under 37. Having said that, 36 is very broad.
Yes.
36 is probably one of the broadest provisions that you will see in this act per se. Okay. It doesn't have any qualifiers. It's very open, saying that, look, any act or any information that's relating to aspects relating to this particular act can be called into question by the government. But it doesn't have the nature of an interception law. It only has a nature of a law enforcement access law. So again, my question here is, look, that section is broad, but if the government, if an official is using that broad section without using their discretion, using it arbitrarily and calling for any sort of information, then I think that particular act of calling for that information could be called up into question before a constitutional court of India. But the very fact that the section exists, it's very broad. The court may actually read it down and say that, look, only in very specific instances where the act otherwise gives the power for the government to call information should this section be used. Or in relation to an investigation of an offence, investigation of any other aspects relating to particular activity which is carried out, should the government be use this particular section 36 is something that the court may read down and suggest. But I would still again believe that we should give it some time to see the actual implementation and practice of 36.
So coming to the other party in the scene, how do you find the structure, the functions and procedures of the Data Protection Board of India? And particularly, will a digital office model uh, will work given India's uneven internet access and digital literacy?
So I mean, so look, I'm not really, because this is probably one of the first digital offices to ever function in India. I think I am quite optimistic about the fact that it's a digital office, because we are looking at a regulation which governs our digital lives, right? Our lives as digital nagriks is being governed by this particular act. Given that fact, one could, at least to a large extent, assume that a person will be somewhat ready to make a complaint even digitally and go through the proceedings digitally. Being a digital office also will give the Data Protection Board the ability to handle the sort of volumes that we're dealing with, ability to serve the whole length and breadth of India's the jurisdiction in India. It can handle the whole of territory of India. By not being present, let's say in a place like Delhi, it actually gives a lot of opportunity, equal opportunity for any digital nagrik to reach out to the digital office. So in that sense, I think it's probably is a better solution than having this physical office, let's say in one place like in Delhi, or even if you put it in the central of India, let's say in Indore or Bhopal, you will face a similar sort of challenge, right? So in one way, what the government has done with a digital office is the fact that it has nullified the tyranny of distance from the regulator and has made it equally accessible. And another question to you, right? I mean, how else do you think or a digital right should be exercised? I think it should be exercised only through a digital means. So that makes it, that makes it all the way that makes all more sense to exercise digitally than through physically.
Interesting. So now next is the act. It bars civil courts from matters for which the board, the Data Protection Board of India, is empowered, and routes appeals to the TDSAT and then to the Supreme Court, going by Section 29 and Section 39. So my question is, why to exclude the ordinary district or the High Court route?
So I think the answer lies in the regulatory design itself, which we addressed as a first question.
Right.
The government necessarily, couple of choices that the government made is, one is it did not look at a right to privacy jurisprudence. Very narrow right to informational privacy is what the government was dealing with under this act.
Yes.
It also did not want to create a very litigious society whereby everyone is filing just a complaint without just a random complaint, sometimes frivolous complaints. Instead, it is created or is dictating a mechanism where first port of call is to the grievance mechanism of the data fiduciary. If that is not settled, then go to the board. Then the board looks into it, applies their mind, and makes, assumingly and supposedly, it's supposed to make a non-arbitrary decision on whether to proceed with that matter, proceeds with this matter. In the process, even sort of suggest a mediation to the parties involved. They can also go through a process of, the data fiduciary can come up and voluntarily ask for a voluntary undertaking in the process, so that what they're trying to do is they're trying to create a non-litigious way and not to further burden the systems, the courts in India, but create an easy process through it. And naturally, from the board, the first port of appeal lies to the TDSAT. One could question whether that's the right or appropriate forum given the current pendency of cases before the TDSAT, and it has got a history of a lot of lags because of the fact that appointments are often delayed, etc. So provided that the government speeds up the process, right, the process of appointment of members to the TDSAT, etc., and then an appeal to the Supreme Court, it follows a similarly tried and tested route which is present in the Companies Act, which is present in the TRI Act. So it's not entirely a bad structure per se, and the reason for that, and if you just look at some of these as well, the government is trying to create a specialized mechanism to deal with these issues. Regulators who are equipped and has the capacity and also has the specialized knowledge to deal with these issues. So it's not entirely a bad outcome, right? It's now a question of how the system now copes up, how the system now finds best way to handle the sort of queries that come up in the
Right.
process
Right.
from the data principles.
So to follow up on this, that but beating this, one always has the option of filing a writ petition or a public interest petition. So this option is open. Still.
Absolutely, absolutely. Yeah. See, but it's sort of narrow. It's sort of narrow as well. I mean, like for instance, you obviously cannot go and agitate before a writ court in India to claim for the same remedies that you would otherwise want from the Data Protection Board. Because there is an alternate remedy that exists, you need to pursue that alternate remedy. Then only can you go before a constitutional court and ask for a remedy from a constitutional court. So that's an established principle which pretty much all writ courts in India follow that to the teeth, and from that perspective, it is the case. But having said that, if there are arbitrary decisions made by the board, and that's where the board's functioning, and that's the reason why we probably need an efficient board to be in place. Probably the very first board itself that's constituted should have the best of the minds in the country to
Right.
deal with such an issue, which is that you will need the board to come up with non-arbitrary decisions, and those non-arbitrary decisions will frame the path for the data protection jurisprudence in India. But if they come up with an arbitrary decision, then that could be challenged before a constitutional court as well.
So now, moving on to the RTI issue, the Act modifies RTI by the virtue of Section 44. It amends Section 8 of the RTI Act. And so, given your background in defending press freedoms, how do you view the interplay between DPDPA and the right to information, particularly the substitution of quote unquote personal information in the exemptions?
Yeah, so the answer is fairly clear, right? I mean, and it's not just to do with DPDPA. Unfortunately, the RTI Act has been there has been an effort to sort of weaken the RTI Act per se. If you know, it's probably a different thinking from the current regime, right? Whereas the RTI Act was probably brought in by the previous regime, and probably the current regime doesn't like it so much. That there has been they've just been finding different ways and reasons to sort of weaken that regime, and this is probably the latest in this whole steps taken, including non-appointment, including aspects relating to limitation of funds to the whole RTI process. This is probably the last step in the process of weakening the RTI here, and it's quite unfortunate because the fact that RTI and a data protection legislation in a healthy democracy should work hand in hand, right? Should work hand in hand to ensure that the data protection protects personal information. At the same time, RTI protects the right to information of the citizen, and we should be able to strike the right balance if we apply to our mind to it.
Right.
But unfortunately, there is no effort which is taken from the establishment to do so, and that's very clear in the case of RTI as well.
So Section 11, it allows right to access, but it at the same time carves out certain exceptions for the state investigatory demands. That is particularly under Section 11(2). So if, say, law enforcement asks a data fiduciary for user data, and the data principal is not informed, so does that feel balanced?
So it's a very tricky question. So I think, see, the interesting aspect about that particular section is the fact that, look, we have two different regimes working in parallel. One is a law enforcement access regime, whereby information about you is accessed from the law enforcement department at this point of time, right? So I don't exactly remember the BNSS equivalent, but the CRPC 91. In the well CRPC, the 91, the police can issue a notice. It can issue a notice to you. It can also issue a notice to a particular platform and ask for information about you. Even at this point of time, unless the authority, right, unless the particular private body has a contract with you, or they have in their standard operating process or practice that they will go and inform the data principal, currently you're also not knowing about it. So even right now, if this were to happen, you're not being informed of the fact that the state is in fact obtaining information about you from an intermediary or a service provider. So that's a question that we need to ask as society. Do we need to actually let the person who is involved know the fact that in fact the state is seeking the information from an intermediary or a platform or a service provider involved? We don't have that legal recourse at this point of time. Second one is with respect to surveillance. That's a second regime which applies. Typically, when in surveillance regimes which involves interception, decryption, etc., and monitoring, again, the data fiduciary does not have the right to know the fact that he or she is being surveilled at this point of time. That frame doesn't exist at this point of time. It's just that the surveillance regime is much more, I would say, the checks and balances there is, at least on paper, supposed to be at a higher one than the law enforcement access which I mentioned on the first one, which is Section 91 and other sections of the Information Technology Act. But currently you don't have that right. So that is a case which is continuing, and that's a debate that we should be having to see whether I have a right to know if the information about me is being sought from an intermediary or a platform. Would that form part of my self-incrimination right? Would that form part of my defense strategy when I stand before a court of law and defend an allegation or an accusation against me in a criminal trial? So that's a deeper question that we need to think about. In fact, for that matter, look, there are multiple aspects relating to criminal jurisprudence, relating to state surveillance, relating to cert access, search and seizure. Like for instance, in search and seizure, for that matter, the checks and balances in a physical search and seizure, which requires a witness to be present, which requires a sworn statement to be signed by the accused whose premises being searched, etc., is not there for digital search, right? So there is even currently there is an imbalance that exists when it comes to digital search and seizure or digital law enforcement actions and often physical law enforcement actions. Given this, I think it's a debate that our society needs to have at this point of time.
Interesting. So moving on to Section 16, it restricts transfer of personal data outside India, and it envisages government notification of permitted territories. So will this have material consequences for the digital economy?
So look, the thing is we are so used to doing business in a certain way across the globe, where the internet was, the USA is like the center of internet for most parts, and that's where typically the information is stored. That has been undergoing a change for quite some time, right? And we need to understand that we have around 13 to 15 sectoral laws which deals with data localization or cross-border transfer at one form or the other. Some are soft restriction, some are hard restriction. We have different sectoral laws which deals with it, whether it's the payments, the banking sector regulations, the credit information companies, the SEBI regulations. In fact, telecom is the first regulation to come which mandates data localization, maps, geospatial data, even cab aggregator regulations have some data localization regulation. So it's the market is now sort of used to a scenario where large amounts of sectoral data should be processed in India and should not be leaving India's borders. But naturally that has not gone to the other sectors, which are the general sectors. And now what the Data Protection Act is doing is also applying to some of the other sectors. Now it's part of the whole digital sovereignty push of India per se. The nature of internet is changing, the geopolitics is changing. So we will see more and more of these regulations coming in. So if your answer is it business as usual? No, it's not business as usual, but I think that's probably something that we need to be prepared for. I don't think there is any other way to get out of the fact that we are not living in a world which was 30 years back. Right.
The dynamic nature of digital rights.
Absolutely.
So the statute, it uses quote unquote as may be prescribed many times, specifically 26 times in the statute, leaving many operational details to rules. So does this level of delegation, does it risk shifting key policy choices to the executive rather than the parliament? And this sounds dangerous.
Yeah, so I mean, I don't think it's a risk. It's already shifted, right? It's already shifted it from the state to the parliament to the executive, and that's something that the parliament has already approved, right? So it's already shifted, and I'll tell you the reason why it's designed in that manner. Now, I'm not saying it's a right thing or the wrong thing. The reason why it's designed in a manner is to sort of ensure that, look, technology is ever changing. It's very difficult to get legislation out in India. if you try to operate the wheels of rulemaking in India, it will take you around 15 years, as evidenced by the fact that it has taken us so many years to get to this position where we have an act, and even now it's not enforced, right? So to be ahead of technology or to regulate technology which is ahead, we need to give more powers to the bureaucracy, more powers to the executive. That is the thinking behind this structural design. It's a choice by the Indian government. Now, it is not always ideal. It is, if it's used in a judicious manner, if it's used in the best possible manner, then, and if you live in a world where everything is hunky dory, then of course there is no problem. Yeah. But we are not living in that world, yeah. And given that fact, you will naturally see some amount of excesses, and we as a civil society need to step in if we see those excesses. One example is the fact that the data localization as a concept or a feature is not anywhere present in the Act, but finds its mention in the rules, right? Which means that the executive can at times step out of what is a realm prescribed in the Act, and by doing so, one could argue that they haven't, in fact, because of the fact that the Act is so wide that they have a lot of freedom to do that.
Right.
So each of those actions, which unfortunately will have to be now tested out in a court of law, if someone is agitated, someone is aggrieved by those decisions being unconstitutional, and I think that's probably the way that we have to move forward. So it's a tricky balance.
So with respect to penalty amounts, what is your view on the penalty amounts in the schedule and section 33? So are these caps proportionate and workable, and how should the board apply the aggravating or mitigating factors?
So I'm sure that the board that we appoint will be judicious enough to deal with and apply the right amount of penalty which is needs to be prescribed for the kind of harm.
Right.
I don't specifically have a view on the penalties. It's just that I believe that now we are looking at a situation where even the most egregious sort of harm, the maximum amount that's paid can be assumed as a cost of doing business than a threat of a penalty by way of criminal imprisonment. If you remember the previous version of the Act, it said that if something was mischievously or used with an intent to re-identify to commit a criminal crime, then that was punished. I believe that there should have at least been a very egregious form of harm which should have been subject to a criminal punishment, so that there are bad actors in this world, right? I'm sure that most responsible corporations that we see in the world today are not going to do this, but there are bad actors. We have seen instances like Cambridge Analytica. These sort of situations should ideally be dealt with by way of a criminal penalty and not just a monetary penalty. So that's my only comment on the penalty.
Right. So to conclude with, recently there are popular concerns and viral claims about foreign intelligence capability. For example, claims that certain intelligence agencies, they have this capability to intercept data globally. So given your background and from a technology and policy perspective, how realistic are those fears, and to what extent should a domestic privacy law like DPDP try to address cross-border intelligence risks?
So it's a fact that, look, intelligence agencies involved in themselves in significant intelligence operations, they're able to sit elsewhere and through backdoors, through other ways of interception, they are able to get in and figure out and gather large amounts of intelligence. Earlier, what used to require them to just be on ground for intelligence or operate by cutting the cables of submarine cables could now be managed centrally and much more efficiently. That's a fact. I mean, someone who is aware of how the intelligence agencies operate or the way in which interception industries or cybersecurity industries in the world work, it's a fact. I mean, I don't think that anybody will try to even disprove or claim it as a conspiracy theory. Those days are gone. Having said that, one of the many things that India has done, right, whether it's with respect to the policies around digital sovereignty, the policies around localization, the policies around having even an authorization in India. I mean, earlier in an earlier world, for instance, everybody used to say, look, let's have the data in India so the government can access if required by way of a lawful process. We can also avoid foreign intelligence surveillance in that. The government is going a couple of steps further. Nowadays, we are talking about the fact that, look, the authorization or the authentication which needs to happen on a network should also be in India, so that we don't want a situation where, look, large amounts of our network or banking or health or critical infrastructure is on systems which are not just Indian service provider but also global service provider. And if a government just decides to wake up one day and say that, look, Indian companies should be offboard a platform because of the fact that we are buying oil from a particular country, or the fact that we have taken a particular geopolitical decision to act aggressively against a particular country, that's not something ideal. So in that sense, the government has been very, very clear, and rightfully so, in terms of promoting more localization, more sovereignty related policies. And Data Protection Act also plays a very small but a significant part when it comes to this overall trajectory with respect to India's building story of digital sovereignty. And that digital sovereignty, which means that our law enforcement should be respected, which means that our court systems should be respected, which means that our process and procedures for protecting the children and the vulnerable in this country should be protected, is being enforced by the government. And that overall strategy is what is making a difference. And like I said, Data Protection Act is playing a small yet significant part when it comes to this overall trajectory and policy and strategy of the government.
Right. So, any concluding remarks on the DPDP Act?
No, I think I'm always optimistic when it comes to any new development, and this is something which has been in the waiting since the time I was a law student.
Yes.
Now I'm about to reach 20 years of my profession, and finally I'll see this coming into force. I'm quite glad, though it has taken 20 years. So I'm quite optimistic that we will use this statute, because we are Indians are quite wise when it comes to using the limited resources that we have. You can call it jugaad, or I call it the hacking of the law. We will find innovative solutions to the problems that we face. We will make the system work very hard for us. We are very, very good to know that. So I'm sure that we will all reach a very positive outcome, and not just us, the India Inc., the multinational companies that operate in India, the government. I'm sure we'll all strive towards finding the right sort of equilibrium where both the advancement of commerce and or better protection of rights on digital age will be balanced, and definitely and hopefully we'll have a better future.
Okay. So I thank you, sir.
Thank you very much. I really enjoyed the conversation.
Thank you, sir. How was it?
It was great.